thought before we proceed to our next and last honorees, that we ought to acknowledge Mrs. Catherine Stevens, who is here. Ms. Stevens, if you would. There's Emmett Sullivan. Our next and last set of honorees, also related to the Stevens case. We have someone who, as the cliche goes, needs no introduction. When Ivey was the two-time state's attorney in Prince George's County, before that, an assistant U.S. attorney. He's now in private practice, but everybody here knows the good work he did as prosecutor, and you're the kind of prosecutor we need in office. Go ahead.
Thank you very much. Good evening. To paraphrase Justice Brandeis, sunlight is the best disinfectant. And after presiding over the Ted Stevens case, Judge Sullivan decided that some extra sunlight was definitely in order. So he took the unusual step of hiring a special counsel to investigate the allegations of misconduct. He wanted a thorough investigation conducted by the most seasoned and respected counsel who could announce their findings with unquestioned authority and integrity. So Judge Sullivan turned to our next two 2014 Constitutional Champion Award winners, and they exceeded expectations. They generated a detailed and unflinching report that left no stone unturned. After a 2-year investigation, they brought to light the countless instances of government misconduct that stole away Senator Stevens' constitutional right to a fair trial. But in addition to confirming our worst fears and suspicions about this government misconduct, they reinvigorated and re-energized the call for long overdue discovery reform, not just for individuals who can mount multi-million-dollar defenses, but also for the clients of Gideon's Army. One day when we finally put an end to trial by ambush in federal criminal court, one day when federal prosecutors finally realize that justice can be obtained not in spite of discovery, but because of full discovery, then we will look back on this report as a crucial milestone in the long journey to a fairer criminal justice system. So tonight, please join me in honoring the authors of that landmark report, Hank Schuelke and William Shields.
Thank you, Glenn, for your kind introduction. I want to thank as well Jimmy Sloan and the board of the Constitution Project for this award, which honors us perhaps more than we deserve. Judge Sullivan appointed us to conduct this investigation. We did so in my judgment thoroughly and fairly. We accomplished our purpose in large part because of the prodigious efforts of Bill Shields, to whom I'm forever grateful. But I feel a tad sheepish about this award. It is described as, for those who defend the Constitution in the face of adversity. Well, as I said, I think we did the job for which we were appointed to do. It was arduous in some respects. It was, to me, personally painful, because as a proud alumnus of the Justice Department, which I remain, I found it very painful to arrive at the conclusions which the facts required us to reach. And I suffered, as one always does in these situations, the slings and arrows of critics. Some who thought we were not hard enough on the department, and some who thought we were not. They were too easy on the department, all of which falls under the rubric, no good deed goes unpunished, I suppose. And so that's the sort of tenor of whatever adversity there was, in my view. I've told this anecdote once or twice before, and so those of you who may have heard it, forgive me. But at one point, somewhat late in the process, Judge Sullivan and I were speaking, and he said, Hank, so knowing what you know now, would you have answered the phone the day I called you? I said, of course, Your Honor. I think what I'm really trying to convey is that while we are honored indeed for this recognition, I think in addition to Brendan and Rob and the Williams and Connolly team, who have my congratulations, the true defender of the Constitution in this case and throughout his time on the bench was Emmett Sullivan. And I should like you all to recognize that. Now, as Brendan has described, what we discovered was a case in which the government's failure to disclose exculpatory material to the defense was rampant. It was, we concluded, in several respects, willful and intentional. It's not, however, the only such case. One would think that in the wake of the outcome of the Stevens case, and in the wake of our report, serious change would have occurred at the department. I don't believe that's so. It is true that Attorney General Holder and his senior subordinates redoubled their efforts to educate prosecutors across the country. And I think they probably have put in place a program to accomplish that, which is about as good as it could be. But this is not, in my view, about education. This is about the recognition that trial lawyers, all of us, want to win. And in a perverse way, the higher the visibility of the case, the greater that impetus is. And so you have prosecutors, not all of them to be sure, but you have many of them who say, this little piece of garbage, and do I have to turn this over? No, I don't think it's material. And that's the standard reply. Of course, they don't know precisely what the defense will be. They don't know how the case is going to develop. But they make this judgment up front, no, this is not material, and therefore we are not required to turn it over. This policy is actually articulated in the U.S. Attorney's Manual, which had been revised in the wake of the Stevens case. And it provides that prosecutors should err on the side of disclosure. And even if, in their view, Brady and its progeny don't necessarily require disclosure, if it appears to the prosecutor that this information might well prove to be useful to the defense and perhaps exculpatory, then you, prosecutor, in your discretion, we suggest ought to turn it over. The policy statement goes on to say that this statement of policy does not have the force of law, and it invests no rights in anyone. So what we have ultimately is a policy of unfettered discretion. I believe, based on my personal experience trying cases over the years, that most prosecutors exercise that discretion honestly and fairly. But there have been, since the Stevens case, at least 15 fairly high visibility cases of which I'm aware across the country, which have been reversed on appeal for non-disclosure of exculpatory information. So the discretionary policy doesn't work, it seems. Now, there have been efforts to address this problem through an amendment to Rule 16, which Judge Sullivan and Judge Friedman, who was here as well tonight, have championed. And there has been legislation proposed by Senator Murkowski from Alaska, which would provide a force of law to a requirement of disclosure of exculpatory information. Hasn't happened. Hasn't happened in large part because the Justice Department opposes it. The Justice Department says, well, if we had a mandatory rule or a statute that required disclosure in certain defined circumstances, that would just breed more litigation. Well, isn't that what we do? That's what we pay you to do. And would you rather engage in the post-conviction litigation in which you've been engaged now for years trying to defend your non-disclosures in the trial court? Makes no sense to me. The Constitution Project has supported efforts at this sort of reform. I think those efforts ought to continue. But it's going to require yet another spark of some kind. You know, had it not been for the Stevens case, Senator Murkowski, of course, would not have proposed this legislation. And while there were a number of long-time friends and colleagues of Senator Stevens who remained in the Senate and on the Judiciary Committee, it had a half-life of about 6 months before the issue basically died. So I believe we, all of us who have an opportunity to participate, whether it's by way of contribution to the Rules Committee, or whether it's by way of trying to interest members of Congress, I think that's what we ought to be doing. So I thank you very much. And Bill, would you please?
I feel like I'm in the company of giants here, but I want to first thank Ginny Sloan and the Constitution Project for this surprising and delightful award to Hank and me. And I also want to echo Hank's comments that we would not, any one of us, be here but for Judge Sullivan's tenacious and stubborn refusal to just accept, oh, let's dismiss the case and call it a day. He wanted to know what happened and was tenacious in that and insisted on finding out what happened. And as you know, it's very easy when the government gives up to take the dismissal and run and get out of the courthouse. This judge wouldn't let that happen, and he wanted to know exactly what happened. I'm not going to rehearse Brady to you. I think I'm in the company of everyone here who knows what Brady is and what a painful system the American judicial system is to go through if you're a defendant. But I feel confident or hopeful that what we did in Ted Stevens' case is going to contribute something to what I see from reading the papers and reading the decisions, that Brady is getting more attention now, and people are realizing that it's a critical threat. The government has a monopoly on all the information in most criminal cases. They control the flow entirely, especially with people who can't afford private lawyers. They're not in a position to hire a team of lawyers. They're not in a position to hire investigators. They rely on the government. The government fails to do that. It failed to do that in the Stevens case. And I think people, the public, is becoming more aware of it. And the courts gave us Brady. It's their responsibility to enforce Brady. And I detect a change in the courts. Recently, there was in the last year, in the anniversary of Brady, Judge Kaczynski, who's here tonight, and I just wrote a piece of one of his dissents in December of last year from a petition for a rehearing on bond, where material was withheld from the defense that would have impugned the integrity and credibility of the government's expert. And the panel decided that it was harmless error, it was not material, it made no difference. And Judge Kaczynski dissented from the denial of the petition for the rehearing in bond. And his opening line was that there is an epidemic of Brady violations abroad in the land. Only judges can put a stop to it. And that is a matter of fact. The government writes the rules. They determine what our rights are, what discovery we get. They help the Congress write the legislation. They're involved with any revisions of Rule 16. So the government has complete control of the information. It makes the rules. And what the courts and defense attorneys do their best to have happen is have them comply with their own rules. The Constitution is our rule. The court gave it to us. And it's time for the courts to enforce that for the benefit of the defense. And Judge Kaczynski went on to say, due to the nature of a Brady violation, it's highly unlikely wrongdoing will ever come to light in the first place. In the rare event that the suppressed evidence does surface, the consequences usually leave the prosecution no worse than had it complied with Brady from the outset. Professional discipline is rare. Violations seldom give rise to liability for money damages. If the violation is found to be material, a standard that will almost never be met under the panel's construction in that case. The prosecution gets a do-over, making it no worse than if it had disclosed the information, the evidence in the first place. Quote, continuing the quote from Judge Kaczynski, we must send prosecutors a clear message: betray Brady, give short shrift to Giglio, and you will lose your ill-gotten conviction. Unfortunately, the panel's decision sends the opposite message. And I'm going to be very brief, unlike our report. I'm almost done. And last month, March 25th, from the 7th Circuit, Chief Judge Diane Wood, in the opening line of the decision, U.S. v. Morales, a wire fraud case where there was a Brady violation claim. In her opening paragraph, Judge Wood from the 7th Circuit wrote, more than 50 years ago, the Supreme Court announced in Brady v. Maryland that prosecutors have a duty to turn over, upon request, any material evidence that's favorable to the defense. One would think by now failures to comply with this rule would be rare. but Brady issues continue to arise. Often non-disclosure comes at no price for prosecutors because courts find that the withheld evidence would not have created a, quote, reasonable probability of a different result. And here's the line to pay attention to. We must leave for another day a closer examination of the incentive structure created by Brady's harmless error exception, because the case before us is another in which the Brady violations do not drive the result. To me, reading that opinion from a chief judge in the Seventh Circuit, that's a shot across the bow that maybe times are changing. And my only hope is that if they do change, because Brady is a critical right. If Brady fails, if defense doesn't get material it's entitled to under the Constitution, then the system fails, as it miserably failed for Ted Stevens. Thank you.